So hi, welcome to Encyclopedia of Wiretaps. This is going to be basically Surveillance Law 101, which is an actual law school course in like an hour, less than an hour. So we're going to throw a lot of information out there at you guys. So who am I? I like to call myself a hacker lawyer. It's a term I stole from some of my friends. I was a software engineer for a long time, got burned out, went to law school, which is a thing that very dumb people do when they're burned out. It was fun. I did national security law because it was actually the closest thing to cybersecurity law I could get. After law school, I went to go work for a law firm. I did a lot of work of handling law enforcement requests for customer data for some companies, which is kind of where I learned how to do this sort of stuff. Some of it based on what I learned in law school, but most of this is just sort of practical on the job sort of things. So I am an attorney. I am not your attorney. None of this is legal advice, even though we're going to be talking about a lot of law stuff in here. So unlike a lot of things that people hear about, surveillance law things are almost entirely based on statutes. There are cases that come into play, but unlike something like the Fourth Amendment or First Amendment, where like 99% of what is happening is based on like common law and precedent and what the cases before say, surveillance law, we are literally following the word of what is written in a law that was passed by Congress and signed into effect by the President of the United States. And I'm going to be tossing around a bunch of numbers today. They look like things like this, 18 U.S.C. 3233. I have done way too many wiretap orders, and so I know that that's the PRTT statute. But I'm going to try to explain these a little bit to you. So 18 is Title 18 of the U.S. Code. That's the criminal law code, because all this wiretap law comes out of criminal law. U.S.C. means United States Code. So we mean that we're looking at a statute that's a federal law that's been passed by Congress. And 3233 is the title, it's the specific section of this that we're going to be looking at. And you'll sometimes see numbers after it, like 3233, like paren 1A and so forth. That just sort of further narrows it into it. So you say the Fourth Amendment, even though I just said it's all statute-based, the Fourth Amendment actually does come into play in this area. The Fourth Amendment is what gives us the idea of the reasonable expectation of privacy standard. And most Fourth Amendment law is case law. We have a lot of cases like Olmstead, which is a very, very old case. That was one of the first wiretap laws. That was where they decided that basically claw mics into the walls of a house we're going to decide on. And so the Fourth Amendment is in here, and it sort of sets the background. And what the Fourth Amendment really does is it's going to tell us that we're going to need a warrant for some types of things we get into. The big law that we're going to be talking about here is Title III. It's kind of the law that created the modern wiretap framework. We're going to sort of dive into this. It really was passed in 1968 to prohibit private citizens from using electronic surveillance, from recording people. There's a lot of state laws in this area also, so you may hear people refer to, I live in a one-party state where I can record someone, or I live in a two-party state where I need the consent of both parties to be recorded. And those laws exist. They're a little bit to the side of what we're going to be talking about today. But essentially, Title III is what codified what law enforcement can do with wiretaps, recording calls, getting metadata of our internet traffic, and so forth. And it's very technical. It requires compliance with some very specific requirements that come out of the statute, and that's what we're going to do. I'm going to walk through how I would analyze one of these orders when they landed on my desk. So in 1986, Congress amended Title III by enacting the eCPA. A lot of people in the tech industry have heard about this. It basically added electronic communications, AKA internet sort of stuff, onto Title III. So electronic communications is basically a non-voice communication made over a network or affecting interstate commerce, which is fancy law speak for internet. It included text messages, electronic mail, faxes, other non-voice internet traffic, and so forth. It's you can go pull up 18 U.S.C. 2510, Section 12, if you want to go look at the specifics on all that. And finally, almost finally, we're going to have one more after this, CALEA. So CALEA is essentially the law that said that phone service providers have to give technical assistance to law enforcement when they come to them with a wiretap order or a PRTT or so forth. It basically says you cannot build a phone system that cannot be wiretapped. You must build your technical systems in a way that law enforcement, if they come to you with a valid court order, can get their data. So the last one, which is one that I didn't really deal with, but I wanted to touch on for everyone, especially because it's been in the news a lot recently, is FISA. This has to do with foreign intelligence wiretaps. So essentially, if someone is acting as an agent of a foreign power, this is the authority that you use in order to get their phone records, their internet traffic, and so forth. So the bulk of what this talk is going to be is we're going to be talking about court orders. Just to sort of lay a framework of what a court order is and what I mean when I say this, a law enforcement officer is doing an investigation. He has a reason to believe that if he can hear someone's phone conversations, he'll get some evidence to help him figure out what's happening with this crime. He'll usually go talk to a prosecutor or someone who's an attorney who's going to help him go make an application to a judge. The judge hears it. The judge has to decide if there's probable cause and a couple other requirements we're going to get into. The judge then issues an order. They vary from like 3 pages to many, 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 many pages, and it gets issued to the service provider. And those would be the things that would come across my desk. So there's a couple different kinds of these things that would come in. Really, so I just want to lay some groundwork here. I'm going to talk through each of these. My aim here really just is to educate you about what kind of data you can get, what some of the very specific technical requirements and so forth are. I'm not doing any hype. I'm not doing any scaremongering here, hopefully. Not going to do any editorializing about the benefits or evils of surveillance. This is very sort of fact-based for you. Hopefully, it'll be somewhat educational, because this is not the kind of thing that really gets shared all that very often. Most attorneys who do this do not really go out and tell people about what they're working on with this. So before we do our sort of jumps in, we talked about the Fourth Amendment and how it lays out a reasonable expectation of privacy. One of the distinctions that we get from that is the difference between content and metadata, and that's going to be key as we analyze each of these orders. So content is the body of the letter. So when the Constitution is being written, people, use postal mail, and then I think, like, okay, so if I'm going to write a letter to someone who's going to have all the details of like my bank robbery conspiracy and so forth, this is pretty detailed information. But there's also a lot of letters that go out that are very private. People write letters to their family. They might be at that time, especially conducting business by letters and so forth. And so if we're going to have some privacy protections, we really want to make sure that it would protect that. But at the same time, a letter has to be addressed. And we would call that to and from information metadata about the letter. And we have kind of a lower bar for the privacy information for that. This is in the days before ad targeting and all of our awesome machine learning crunching things where we can actually derive patterns from metadata much more easily than it turns out that you could in the 1780s. And so they thought it was fine to have essentially lower protections for just this addressing information. Sort of the idea was, well, the addresses are on the outside of the envelope, anybody can see them, as they're in the mailbox or so forth. But so we have essentially the split in how we think about data, whether it's metadata or content data. Content data requires at least a warrant. And to get a warrant, you basically need a judge to determine this probable cause, which is essentially a reasonable basis to believe that there has some evidence that a crime has been committed, or there's some evidence for an arrest or so forth. And you have to be a little particular about it. You can't just say, I want a warrant to search a town. You have to say, I want a warrant to search a particular house, because I believe that if I go search that house, I'm going to find evidence that relates to a bank robbery that occurs 2 weeks ago, and here's a little bit of reasoning that I have for that. If you take Crim Pro, you learn all kinds of things about what you can base warrants on and so forth. It gets very technical also. So one of the first things we're going to jump into here, I'm just going to lightly touch on these, is stored content warrants. So these come from the Stored Communications Act, part of the Electronics Communications Privacy Act. Title 2 of the ECPA is the Stored Communications Act, and it basically says that you need a warrant to access stored content. This is the one that says, like, if your email is over 180 days, that you wouldn't because people thought it would be abandoned. That's actually no longer true. Pretty much every provider requires a warrant. There's a case called Warshak that sort of applied to that. It's one of the few places where case law does come into this. But it's basically like, hey, do you have content on disk? Yes, okay. Like, here's the court order for it, please return it. The other kind that we have is a subpoena. So when we were talking about the content versus metadata thing, we said that metadata does not need a warrant. Metadata instead needs a subpoena, which is still a court order, but it has a lower threshold to get it. So instead of needing probable cause, we're going to have some specific requirements that we'll see when we jump in. So pre-Carpenter, cell site location records could be gotten with subpoenas. And Carpenter's a Supreme Court case that was just decided at the end of June. It essentially said that, like, even though these address records are considered to be metadata, because it was just basically like locations where there were pings on the cell phone tower, that, we're now in the age where we can start combining this information and it creates a richer picture and it gets closer to the sort of the richer picture of things that we had wanted to protect with warrants. And so the Supreme Court essentially said you can no longer just use a subpoena to get, like, cell site location data from the service providers. A PRTT is a specific type of a subpoena. It's pen register, trap, and trace. This is the 18 U.S.C. 3233. And we're going to walk through one. I had an awfully fun time trying to find some examples of some of these orders for you guys. So I think this one is okay. Some of these might be a little blurry because we're getting, like, scans of typewritten pages and stuff. They're fun. Most of these orders, when they come out to an attorney, I'm going to say most, it's probably almost all, have non-disclosure orders on them, which means I cannot say that I've seen an order to wiretap a particular person. So they're not available in the public court records. So in order to do this sort of thing, you have to go to training materials and so forth and pull things that are not really quite real. So we're going to look at one that essentially comes from a training reference manual. My last slide is going to be a list of links, which is the sources where I pulled all this material. So if you are interested in taking notes and so forth, you can basically pull that last slide. I'll post the slides and everything so you can pull from them. So this is pretty much what an order looks like when it comes in. We would fill it up at the top where it says District Court. For the, it'd be like Northern District of Illinois. Some of them have separate divisions. In the matter of blah, 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 we'd have our case number. And you notice right up here at the top, we have that this is under 3122, and so it's telling you, like, hey, we're going to be in PRTT land. This is essentially what we're going to, the set of rules that we need to start looking for. And I should put my glasses back on here. I'm sorry, I'm leaning in here. We need to uniquely identify the device that we're going to be doing it for. So we might have an IMEI number in here or an ESN. And then you say identifying the telephone number being used by. We have to have a subject name in here. Or we have to say the whole, like, first name unknown, last name unknown. It's required by the statute. If that's not in there, you don't approve the order. That used to be one of the things I would kick orders back for all the time. I'd be like, no, like, you didn't give me the name. I know you don't know the name, but you have to tell me you don't know the name. And you have to say it's in connection with an ongoing criminal investigation. So we would literally have checklists of what the statute required as we read each of these and check them off as you go down. So that was the first page. So we're moving down in the order. So we have to note here up at the top that the information to be obtained is relevant to an ongoing criminal investigation. Has to have that exact wording. Conducted by, and then here we have what the agency is that's doing this wiretap regarding. And we have to have one of a certain number of crimes because these can only be used to investigate particular crimes. By, and then the subject, because the subject may not be the target. So like if we suspect John Doe of doing a bank robbery and we're wiretapping his buddy's friend, like the names may be different in here. And then a lot of this ties on identity. We want to make really sure that like we're getting the right phone line that we're going to tap here. We have to say the identity of the person is leased or whose name the telephone line or other facility which the pen register top tape is to applied is, they either say is unknown or they tell us that they have the name. It's almost always unknown. And then we have to say the order applies to a telephone believed to be operated by the subject. So again, this text all comes from the statute, and you're basically doing a check mark as it goes down. If any one of these things is missing, and it's essentially a required element, like we don't say the person call out that it's like the person who's leasing the phone line, you reject the order, it's facially invalid, it cannot be, we cannot return data under it. So we go and may install and use anywhere in the United States to record or decode the phone numbers, and we're sort of down here, we say the order shall be effective for 60 days from the date that this order is signed by the court. So a PRTT can go for up to 60 days. After that, if you're still investigating, and you're probably still investigating, you essentially apply for a renewal. So you have to go through and do the same exact thing. You have to go back to the judge with the application. I think you pretty much tell them, like, this is a renewal, because they come back to us with the orders marked as renewals. If they're giving you date in there, like from January 1st to, you have to check that it's 60 days or less. If they try to give you a date range that is 61 days, and you actually use like these little calculator things to figure out the date range, it's again invalid. You cannot approve an order for more than 60 days. And these sealed by the court. This is a order with a non-disclosure order. We could not, go out and like publish this in the public court records. So,
Sorry, this may have eluded me. What exactly is the purpose of a pen register and traffic trains? What are they?
That's this. We're getting there. So basically, it allows you to collect non-content information associated with internet communications. This came in 2001. U.S. Patriot Act amended the PRTT statute to do this. Some people debate about URLs, I believe. So essentially, for most people, you're looking for like email subject line. You're looking for URLs visited, like things that are considered internet metadata. Or if this is a phone line, you're basically looking for the register of what numbers were called and when, and they use that to essentially figure out who your contacts are, I believe. So that's what you would be getting with one of these. It's metadata, but again, like if you're getting the subject lines of everybody's email, you may or may not be getting a lot of stuff. Title III Wiretap came from the 1968 Omnibus Crime Control and Safe Streets Act of 1968, which I think is a hilarious title for this thing. So note here that we're talking about the federal authorities, and they're essentially a baseline. States sometimes do also have their own wiretap statutes and so forth. They're sometimes a little bit different. It's like Arizona authorizes a little bit more subscriber data with some of these than some of the other ones. But they are almost all modeled on the federal ones. And I have the most experience with federal, so I'm going to be presenting those. But do understand that pretty much every state has a state equivalent of this stuff. And so it does mostly preempt state law. The states have to meet that bar. So I really did not get enough wire jokes into this thing. I apologize. I thought there would be tons of good ones. Essentially, wiretaps, because it is so intrusive, we're basically bumping up the bar on probable cause. You need not just probable cause, you need some other requirements. And one of them is necessity. And if you've seen The Wire, you remember they had to go say, like, hey, we know that there's this criminal conspiracy in the streets of Baltimore, and we're just not getting the evidence of the crimes that are out there. We really need to tap this payphone. We're not getting this information any other way. And they really have to list out in the application, like, we tried alternative investigatory methods, and we really need to do this intrusive way of getting our evidence. You basically are supposed to list out like what you've tried and failed. If you are wrong on this, essentially if you lie, that is actually grounds for getting evidence tossed out in court. So this is something you don't want to mess up. You need to basically describe exactly what you expect to get. Obviously, you don't necessarily know, hey, I'm going to hear Joe Smith talk to Bob Smith about stealing cookies out of the cookie jar on Tuesday. But you can't just say, yeah, we think that guy is a sketchy dude and we want to wiretap him. You got to be a little bit more than that. It has to be the full and complete statement of facts and circumstances, including details underlying the alleged offense and a particular description of the nature and location of the facilities in place to be wiretapped. It's like when I was calling out the PRTT, we have to mention the name of the person who owns the line, who the line is leased to, and so forth. We need that level of particularity here. Roving wiretaps, none of us pay long distance anymore. I certainly have not paid long distance on my phone anymore. There's not really much of a concept of roaming. This, I think, used to be a bigger thing, where you would go to a court that's just in one district, and you would say, hey, I want to wiretap a phone line that's here, and it was fixed to a landline in there. And then if the person moved to another state, you'd basically have to go get another order for another phone line in another state. Our tech kind of breaks this. So it's basically, if you have a wiretap on, an internet service like that, it's kind of hard to tie that to geography. But there's a whole concept of roving wiretaps. I don't want to dive too far into it, but you can certainly go Google and look up some of this. Time period. When I said PRTTs are 60 days. Wiretap is 30 days at most. Again, they sometimes give you date ranges, and you need to do the math to make sure it is only 30 days. Includes holidays. They can start whenever, because this is all done electronically. It doesn't really matter if you want me to start at 12:01 on Sunday morning. That's fine. It also, the orders will say to begin immediately or within 10 days of the order being released. So it's going to go up to 40 days from the date the order was signed. That has to be checked also. If essentially the law enforcement agency slacks in getting the order to the service provider and you don't get it until 11 days later, so you can't start it, that's grounds to send it back and be try again. A lot of this stuff gets sent back with notes. Be try again, you were incorrect in this spot. And again, they can be renewed. You see a lot of renewals. It's 30 days at a time. You have to keep going back and say, we still think that we need evidence, we still can't get it any other way, and so forth. So we're going to sort of walk through one of these, and we'll see a lot of these requirements we're just talking about. It looks pretty similar to that PRTT that we just did, and hopefully that is somewhat readable. I apologize. This is the scan from the typewritten attorney manual. I had a fun time finding some of this information for you guys. So up at the top, we say, this is the district court. It's in the matter of the application for the wiretap. Order authorizing the interception of, it would be wire if it's internet, or oral for recording phone calls. And we have to, essentially, the judge is going to say, yes, someone came in and said under oath that they're applying for this. And as they note at the bottom, it's basically going to be a copy-paste from their application. And I think this is on the next page. We have to state this probable cause for the specific crime mentioned in Title III that the wiretap can be used to investigate. I believe so. Yes, there's probable cause to believe that. And then you have to state the people who you're investigating, who are the targets of the subject, have committed, are committing, and will continue to commit. So this list of offenses comes from 18 U.S.C. 2516. You have to check that it matches that list. If they are trying to investigate something that is not on that list, that's a reject. And then you say, probable cause to believe that I'm going to get some evidence from this particular wiretap that is going to help me investigate it. Sorry, it's small and blurry on my screen too. And so we have to say the interception of the wire communications. Note that again we say subscribe to, located at. If we don't know these, we say unknown. It cannot just not say it if you don't know what it is. And this is where, again, you have your checklist. Do you have this? Do you have this? Do you have this? And you're going down the order and marking it off as you go. You say, well, concern the specifics of the offenses that are on the list, the manner and the means of it. we have to also, we specify a place the interception will occur. Although, as we just said with the roving stuff, like it's a little theoretical with some of the internet stuff. Like if you're going to a social media company and doing, an order for that, like it's a little bit weird. This is where also we have to say specific investigative techniques have been tried or are not feasible. That's in the paragraph C. Has been established that normal investigative procedures have been tried and failed, reasonably appear unlikely to succeed if tried, or too dangerous to employ. And it's going to be pretty much copy-paste into that language from the statute. And there's probable cause to believe, so this is where we're calling out that the judge believes that they have adequately demonstrated probable cause for this. And then we say, we have to specifically have the judge state that they are authorized to essentially go do this. If there are state officials in there, they will list them out also. You see a lot of times sort of partnerships between state agencies and federal agencies that are doing the investigation. That gets listed pursuant to the power delegated by it. So the statute basically says the Attorney General of the U.S. can authorize wiretaps. Attorney General of the U.S. is a pretty busy dude. And so he delegates that down to like the U.S. attorneys and so forth. I actually don't remember who specifically is authorized to do that, but it's like you're not getting the Attorney General to sign every single one of these, even though the statute essentially says that that's what is required. And then to intercept, and we call it, again, whether it's wire or oral. This is the termination clause. The statute says you should terminate a wiretap when you get the evidence that you want. I don't think that's super common. I think they keep doing them. I don't know, maybe they do. So basically, this whole like reveal co-conspirators, that language, I swear, is almost boilerplate. You'll see it a lot. And others, yet unknown, committing these offenses. So essentially, a lot of this is they're pursuing crimes of conspiracy and so forth, and you want to keep figuring out who is in these networks, and so they use the wiretaps and so forth to sort of hop around them. One thing that is a little hard to tell from this training one here is that oftentimes they're combined. You will see an order that will have wiretaps on 5 people and PRTTs on 4 of them. And it'll kind of be mixed in, which is fun when you're trying to make sure that you're checking off all the boxes. And so what we have in here, oh gosh, I can't read it. Somewhere in here it says it applies to changed phone numbers also. This is to try to deal with like people SIM swapping or so forth. And so basically it says like, hey, if you have this phone and the number changed, but we know the person's over there and we can trace it, like we're not going to make you go reapply. It applies back over. And we have a technical assistance clause in here saying that the provider has to help essentially get the data and return it. Non-disclosure clause is in here again. To avoid prejudice to the government's criminal investigation, the provider of the electronic communication service, its agents or employees are ordered not to disclose or cause a disclosure of the order. So if you came up to me and said, did you see a wiretap for Bob Smith, I would not be able to tell you if I was the attorney who processed that because it's a non-disclosure on that. We have our time period of 30 days in here. The order shall be executed as soon as practical, so forth. Within 30 days measured from the earlier of the day on which the investigative or law enforcement officers first begin to conduct the interception, or 10 days after, that's where we have to return it. And they ask for the reports to the court, so the court is supposed to be monitoring that they're still getting useful stuff from this, and our target hasn't just like given his cell phone to his 5-year-old kid, and the 5-year-old kid is on like the phone like babbling off, doing whatever. We're not getting any sort of active, useful investigative material from this anymore. And then we have to check the judge's signature and the date. It's kind of amusing to me how often we get these without a judge's signature on it. I guess, the clerk would print them out, give them to the judge. Judge would be tired going through a stack of them and would miss a few. So you would always have to check that. A lot of times we get not just a date, but a time. So it'd be signed, like the 1st of April, 10:40 a.m. And so the wiretap goes for 30 days to like whatever. So if it was like April 1st to April 30th, 10:40 a.m. at 10:41, it's supposed to kick off, although probably by that time they've gotten the renewal. And so it would go forward from that point. But not valid without the judge's signature. There's also the concept of a consent-based order. These are a little bit different. They go for longer periods of time. They'll go for about 60 days instead of 30. I think some of them go for 45. I can't remember the specific ones. To approve one of these, you basically need to see a signed consent from the person whose communications are being monitored. Obviously, you're not going to know under what circumstances that was signed, but you have to look and make sure that, the person signed their name and the name matches and it appears at least kosher. D orders. I don't think I ever saw one of these independent. They get tacked usually onto wiretaps. It has to have the specific language, the specific and articulable facts showing there's reasonable grounds for this. If that language is not in there, you do not approve the D order. You can approve a wiretap if they had this in here a little bit wrong, or they might have just said with specific facts showing they didn't put in the and articulable, and it was in something with a wiretap. You can approve the wiretap, you reject the D order, you bounce it back, incorrect statutory language, come back to me with something else from it. There are some jurisdictions that will routinely screw up the D order, and I don't know how they ever get their data because we would certainly not approve it with the incorrect stuff, and they just would carry on. So who knows what's going on with some of those. I think a lot of this is very templatized on all sides, and the courts would just basically have their orders they would do, and if it had incorrect language and the law enforcement wasn't telling them, hey, fix it, it would just carry on. But basically, the subscriber data is basically like information about who you're contacting. So now we're getting into some of the fun national security stuff. So national security letters got a ton of attention. A couple years ago, people were all up in arms about the warrant canary thing. I actually wrote a little law review article about warrant canaries. They're very trendy. They're still very much a thing that's out there. They're different from a wiretap in that essentially they're an administrative subpoena, which means the agency has its own authority to issue them. So people get very concerned about them because you don't even have a judge. Like people say, oh, the judges like rubber stamp warrants. There's no judge involved at all. The agency has its own authority to issue these requests. They are, however, very limited in the information that comes back. It's essentially subscriber sort of data that goes back. We've had NSLs since 1978. There are 5 different places or essentially agencies that can request types of data for this. Financial data is the first one. Financial data essentially is the second one. The ECPA 2709 can request them also, and Section 802 of the National Security Act, so that gives like the FBI and so forth the authority to go request this sort of data. They get used a lot. I don't remember off the top of my head if there have been wiretap numbers released, but the wiretap numbers are probably way, way higher. These are not small numbers of pieces of information going out, although between 2016 2017, you can see they're somewhat similar. These are from the Office of the Director of National Intelligence, puts out a transparency report every year, and you can go pull it up and look at the numbers. I think that might have wiretap numbers in it also. People like to dive in and sort of compare what's happening year over year, and then also take the numbers that are in these transparency reports and compare them to the information released by the service providers and try to do math and see if they add up or not. So we get into 702. This is what FISA orders are done under. The FISA court is a special court. It is still what we would say an Article 3 court, which means there's federal judges on it. Everything in it is classified. Essentially, the judge approves these requests. He's not using the normal, well, I'll say normal, like the requirements that we just looked at for a warrant. He's using different, like, essentially foreign intelligence sort of requirements, like, do we think this person is an agent of a foreign power? Is it someone who's outside the United States? Is it someone who's acting against the interests of the United States? There's a lot of confusion about these. A lot about these is very cloaked in secrecy because everything having to do with these is classified. I worked with someone who worked on these and I never saw one. because I did not have a clearance for them. But as it turns out, as I was doing this talk, the Carter Page FISA warrant was released. So I was like, oh, this is kind of cool. I can actually see what one looks like. So I did not reproduce the entire thing in this talk, but I figured we would take a look at it to sort of see how it compares to the other ones that we just looked at. So you can see on the surface, this does actually not look that different from what we were just looking at with the Title III and the PRTTs. Instead of saying a district court, we say it's the FISC. It's an order down here, just the same as we saw with the PRTTs and so forth. We say the application was made pursuant to, instead of saying pursuant to 3233, we're pursuant to the FISA Act.
Why would they black out the specific
Classified. Then information is either still classified, or if you look at the little markings next to it, those are FOIA redactions. So the Freedom of Information Act says that when information is released, you can hold back information for certain reasons. So like B6 is a common law enforcement one. I can't remember what B1, B3, B7 are, but you can pull up FOIA and see. So they basically are asserting that they can't release this information due to these.
doesn't everyone already know what the FISA Act is?
Yes.
That part is blacked out.
Well, we can't see what the specific statute number is because it might tell us how many different sets of authorities are underneath because they're numerical.
Okay.
Yeah.
Okay, thanks.
So it might be like, so it's 50 U.S.C. instead of 18. It may be like sections, 1 to 5, and we're like, oh, there's at least 5 sections because they go numerically.
So that's interesting. So 50 is not criminal code.
No. I don't remember what 50 is. It would be one of the national security-ish type ones. Yeah, I actually thought this would be under 18, but it's not. Yeah. So we have to assert that Russia is a foreign power. I love how some of these things you get, and it's asserting like things that you would be like, well, duh, like very basic facts, and yet because the statute requires it. So I'm saying you probably have to assert that because it says it can only be used against a foreign power. So we can essentially reverse engineer what the statute is requiring by looking at this warrant, at what they didn't redact out. And we say Carter Page is an agent of Russia, so that must be required. The minimization procedures proposed in the application have been adopted. So FISA 702 is the minimization procedures is this whole thing. I don't even want to touch it because it's a hairball. You should research it. It's cool stuff. It's a hairball. And then he has to say, similar to what we say in a lot of the warrant ones, that all the certifications required by statute have been met here. And notice again, they blacked out the statute number. So we can't tell which statute is requiring these statements. We can say it's not clearly erroneous. So this is probably another statute requirement that is in there. That's not text that we usually see in a warrant one. Pursuant to the authority conferred on this court, we're going to say that the United States is, I'm at the top of the second page, the United States is authorized to conduct blank of the target as follows, and this is where they're going to be saying, like, you can get the email subject lines, you can get the URLs, whatever they're actually getting here, because we don't know because it's been FOIA'd out. I didn't go through the whole thing, but it was kind of interesting sort of going through all this and seeing the pieces. It's pretty long.
This was released by the House Select Committee on Intelligence, right?
It was released, I think, it might have been released by DOJ. Yeah, you might be right. I don't remember.
But it was supposed to be like evidence undermining the Mueller investigation. Yeah, I don't see how it serves that purpose.
It's so blacked out. Yeah, I mean, I was mostly interested in it because I never particularly thought this through, but it makes perfect sense that this is facially similar to the non-classified warrants that we handle for regular wiretaps. Yeah. So this is just a little bit of notes about 702 allows the targeted collection of content. About collection to, from, and about the target, we can do a couple different hops around. Backdoor searches are basically where we already have this data available and the FBI has a target and they want to go see if there's anything in the already collected data about it. The last ODNI transparency report, so there are 129,080 individual groups or entities who are targets. So, after we just went through all these statutes and I said, case law doesn't really have much to do with it, we're going to touch on All Writs Act, which is kind of case law and is very fuzzy and is a weird, wiggly little area. This is kind of a catch-all because especially all these things have very specific requirements. Way back in 1789, they decided we better make sure we can always get the information we need, and we're going to make this All Writs Act. And it was actually enacted to enable courts to always be able to go get the information they needed to pursue essentially their role. So 99.999% of the time that this law is used, it's by a court basically saying, I need you to go do something like some really arcane, small, like land dispute or something. Like, it's not a big deal. It gets used all the time. Most states also have a version of this for their state courts. But it got used for the Apple iPhone unlocking a couple of years ago. Essentially, the FBI had, the phone. They wanted the phone unlocked. Apple was like, sorry, we can't unlock that for you without writing custom software. This didn't fit in a box of like a wiretap or stored content or something because they wanted Apple to go affirmatively write some new software to do this. And there's not really any provision to do that in our current wiretap statute or so forth. So essentially the All Writs Act says anything necessary and appropriate to aid in the respective jurisdictions. I like this wording, agreeable to the usage and principle of law. I'm not sure how that says I'm going to require a software engineer to go write some code, but DOJ said it was. So United States versus New York Telephone is a case that predates CALEA. And essentially this was, they wanted to essentially install a wiretap. And because CALEA didn't yet exist, the phone company was like, sorry, like we don't have the tech set up for you to tap this, like we can't really help you. And they used the All Writs Act to force essentially the technical assistance that is now codified in CALEA. And they said in this case, basically we agree, the federal courts should not just require third parties to do like anything. They were kind of leaning on it then because they're like, well, clearly, like we have this wiretap sort of law. We should be using it. You phone company are just being annoying, and so we're going to force you because it seems kind of clear to us that you should be allowed to do it. And so essentially what happened with the All Writs Act case with Apple was, they found like some other way to get in because software is always buggy and there was essentially a backdoor to it. But they have not said they won't try this kind of thing again. So if there's another fight over this sort of thing, if we do not have essentially a new version of CALEA that would require writing, software doing other work to affirmatively unlock phones or other devices, All Writs Act could come back to play again. So these are my sources. There is a lot of very boring government manuals up here. I will definitely tweet out my slide deck if you don't want to try to take pictures of super long URLs. Lawfare blog in there is a very conservative blog, but they have people who really know what they're talking about, and so I find it a somewhat interesting read. The thing at the bottom is a book. So when you go to law school, you actually really learn law through like the supplements, and this is a very good horn book that basically taught me Crim Pro. And the top book is an insanely expensive book by David Chris that if you have access to a law library that has it, will basically teach you FISA and so forth. It's very good, but it's like $500 for 2 volumes or something insane. So try to find it in the library. So I think, do I have time for a question or two? Okay, oh wow.
Is this basically the same for wireless surveillance? Like if I was going to bug somebody, this is mainly wired. What
How would you be
now,
bugging,
right?
like you individually doing it?
Yeah, well, I mean like law enforcement. So basically my question is, this is mainly wired. Would the laws be that much different for wireless?
This applies to cell phones.
Just to cell phones and stuff?
Yeah.
Okay.
Yep.
No, not wireless, like electronic surveillance. Like I actually have like a spike mic, pointed at you, and so I'm recording.
It technically falls under this, yeah.
Oh, okay.
Any of that done by law enforcement, something like that. This sort of, like, if you are one person recording, you need a one-person consent or a two-person consent in your state. Anything outside of that is criminal, and you should not do it.
Well, not me personally.
Yeah.
Yeah.
Please don't wiretap your neighbors.
Hi there, awesome talk. So you noted that the wiretap sort of extends to if I swap a SIM in an existing device, then they don't have to go and get a whole new wiretap order, right? They can continue to use the existing one even though the phone number changed because the device identifier is the same.
Or whoever they're keying the identification off of, if it shifts, you can often follow it.
So does that still apply if you get a new device?
So the IMEI number changes?
Yeah, so the IMEI and the phone number both change.
I'm going to say probably. I think it may depend on the company. I didn't handle ones that were like that, so I don't want to give you a definitive yes or no. That may come down to the company policy. I don't think there's case law on that, but...
So it seemed like a lot of the reasons that you were kicking things back was sort of bureaucracy, you know, so this thing had to be lined up with that thing, had to be lined up with that thing.
The wording has to match exactly.
Yeah. Can that be gamed from the perspective of someone who may be a target from this? Is there some way to increase your chances of being a person that makes it, that is more likely to cause a bureaucratic log jam?
Yeah, make the law clerk drafting these get tired and forget to check the statute. But I'm pretty sure that most courts use basically
like a SQL injection in your name or something.
Oh man, we saw some funny names with some of them. Because you don't usually have names, you have known as and whatever. They're like handles or whatnot. Yeah, but most courts are basically going to have, like, on the C drive in the folder orders, they're going to have a, like, PRTT folder. They're going to have a PRTT with a D order, and they're going to fire that sucker up and basically do a find replace. So it's not like they're drafting it from scratch every time.
Hi, thanks for this awesome talk. One question. You were talking about mobile phones so far, but does this also apply to mobile phone technologies, for example, used into connected cars?
It would apply to anything that has an internet connection, essentially. If you can get to a provider and serve an order on them, then they can package in response to the order, package the data up and send it to law enforcement.
So my question is with regards to modification of data that is passed over the wire. Does this only cover, well, you are allowed to record everything that goes over this wire, or are you also allowed to modify the data? For example, enforcing SSL man in the middle or something like that to be able to access the data, because for example in Austria they just changed the law. If you're using Tor or Signal, the government is no longer able to read that if they want to wiretap you, so they now have the right to install a backdoor on your phone. They even may break into your house to install it there in order to get access to the data. So are they allowed to modify your device and or your data stream as well with the wiretap?
I'm going to not answer this one.
Okay, maybe I'll move you to an easier question, I hope. So how does law enforcement decide to whom to issue the subpoena, right? I mean, there's no one service provider that's just operating in a vacuum. Everybody's using, AWS and Google and all these other pieces of infrastructure and other vendors who may have access to the same information for whatever
How do they
reason.
choose who to go to when it's a long chain of providers?
Right.
I'm going to guess, go to the ones they're familiar working with. Some of these companies have very large trust and safety programs, and they hire outside counsel and so forth. This is where I did this kind of work. And those are probably easier to work with, and they may get a reputation to be easier to work with, and people go there. I don't know.
I think I've seen some recent laws allowing ISPs to possibly monitor and or alter data going through the ISP. Can you roughly outline that? And,
About the ISPs being allowed to modify data?
Yeah, monitor and modify data, like 6 months ago? New laws?
Sorry, I'm still trying to figure out so law enforcement gets a wiretap order asking the ISP to monitor or to modify the data that they have?
No orders.
No orders, and they're getting stuff outside an order?
Yeah, new laws allowing ISPs to do what they want.
Right.
And how would that apply to warrant?
I'm just going to say that no client I worked for would do that. I can't say who my clients were. But that's not going to be a common practice among people who have like the big trust and safety groups and whatever, because if you essentially you're following, like you're hiring attorneys to do this checklist, because if you don't, it's essentially illegal wiretapping, which is very serious criminal penalties. So if that's happening, my guess is maybe there's some kind of like a 702 classified whatever thing going on, but I don't know.
Awesome talk. Just to probably add to that, I'm supporting a client of mine in Australia right now who's looking at a civil activity relating to copyright infringement and DNS blocking, which has now actually become a commonplace in Australia. Hit me up sometime during the week.
Yeah, and copyright enforcement stuff is going to be entirely different from wiretaps.
Yeah. Anyway, my question was, I couldn't but help sense going through it. It sounds like everyone has a whole heap of Word docs that they're just doing.
Everyone has a...
So it sounds like law enforcement has a whole heap of Word documents that they're just doing Control-C, Control-V to. Has there been any view to automate and accelerate that process at all? And even clear up some of the data validation piece?
Well, the data that I would see would come from the courts, and courts are notoriously tricky to do nice whiz-bang technology with CPacer. I do think there's various agencies that have various ways to do this kind of stuff. If you go read these manuals, like DOJ CSIPs, they're going to tell you exactly how to create and draft one of these applications. Like, these are very interesting to read. They'll tell you under, like, when you're allowed to use this, what type of investigation, and so forth. As far as automating the legal technology, there are definitely, in terms of the attorneys who do it, they may be doing some automation. I had some because I'm a programmer and this is really boring work. But it's a really high bar to make sure you're always correct. Like, there's not a lot of room for screw ups, and so you know how many bugs happen. Like, you don't want this fully automated.
Awesome. Thank you.
Okay, so this will be the last question. I'm going to be outside at Lockpick if you want to talk to me more.
Some people alluded to this, but can you do this under any spectrum, even without the internet? There's like 900 megahertz, 2.4 gigahertz, visible light, radar.
You would need a service provider to serve on.
So if there is no service provider, they don't have the authority to create a system to intercept a
that intercepts?
spectrum?
That's a good question. They probably do. I'm not that familiar with those. I'm familiar with the stuff like the things the service providers get. So that's a cool research question you should go look at. I suspect they probably can. I just don't, off the top of my head, standing here with no legal research tools, no. So. Yeah, you want to be very careful about recording anything off of this because there's a lot of laws in this area that are very finicky and have very serious penalties. So, cool. Thank you, everybody. I'm so excited you came more about Wiretap.